In a significant decision, the Pretoria High Court has ruled against third wave BEE and in favour of the aviation sector in South Africa. The court ruled it unlawful for the Air Service Licensing Council to subject air service licenses to BEE and race-based criteria. This was after we took the matter at Sakeliga to court last year. This legal victory represents a step forward in the fight against regulatory overreach and third wave BEE. Specifically, it is a victory for airlines, air services businesses, and all air services users within South Africa. As part of the ruling, the court awarded costs against the Air Service Licensing Council. So why did we take this matter to court? Since at least December 2023, the ASLC had been denying and frustrating domestic air service providers, withholding operating licenses, demanding BEE compliance, and forcing various forms of transformationism. This was unlawful and contrary to the ASLC's statutory mandate stipulated in the Air Services Licensing Act. This act strictly requires that the ASLC must issue licenses when an applicant complies with requirements on safety, residency, control, and registration of aircraft. Importantly, the Act precludes the ASLC from adding additional requirements. There is, therefore, no basis in law for making race, transformation, or BEE a prerequisite for air service licenses. By introducing licensing criteria that have nothing to do with operational standards, the Licensing Council's licensing practices compromised commercial freedom and the availability of local aviation services. After the Licensing Council ignored our warnings in 2024, we initiated litigation. And now, as of August 2025, the case is concluded and the court has ruled in our favour. As a further component to this case, the court also declared the ASLC's prohibition on the use of electronic devices during hearings and on making recordings of interactions with staff unlawful. In our view, these actions by the Licensing Council represented attempts to evade public scrutiny. During hearings, applicants found themselves confronted with arbitrary verbal demands regarding BEE and transformation, which often appeared nowhere on paper. This ruling is a significant win against third wave BEE, in which regulators unlawfully seek to make BEE a precondition for simply operating a business. Since roughly 2018, the regulators have improperly and unlawfully sought to increase the scope of what they may license, while simultaneously attempting to tie those licenses to BEE requirements. This effectively aims to turn BEE into a prerequisite for participation in the economy at all. Despite this win, there is more work to be done. The International Air Services Council, the local regulator responsible for international licenses, has been making similar BEE demands of major international airlines and local companies engaging in international air services. This has caused diplomatic unease, having affected airlines from the Americas, Europe, Australia, Africa, the Middle East, and elsewhere in Asia. Sakeliga is at an advanced stage of legal preparations to challenge the International Air Services Council's requirements on grounds similar to those in the local council's case. We're also considering options regarding what appears to be race-restrictive requirements by other aviation regulators and state entities related to aviation and, of course, beyond. Thank you for your continued support. We'll continue to keep you updated as we pursue similar challenges in other areas.